Due respect to this honorable court. Due respect to this honorable court. UA Samson. Due respect, are you hearing me? Due respect to this honorable court. Due respect to this honorable court. UA Samson. For the first, second, and third defender.
Yes. Good morning, Council.
Good morning, my lord.
Yes, I'm appearing for the first, second, and third defender.
Come.
What time? Since you are using this one, you have something. I'm hearing that. I'm not hearing you. Can you hear me? That's nice. Do I even appear here? This is something now. This is something. That's me. I think that's something now. Can you hear me? I'm not. Darling. It's on now. Why is it not going? Darling. Darling, right now. Participate. Participant. What? I want to judge the participants. Chat. What one would be chat?
You are typing.
Let's leave and come in again.
If you leave and comment, it may take time.
No,
Don't worry, just if they're setting something. Click on that note first. Click on it. First one.
What is this? That's all muted. Maybe they've been muted from the other side. Like maybe you've been muted from the other side.
You should be able to hear.
I heard something now. I heard something now.
Good morning, Leonard Council.
Can I hear you now?
Can everyone hear me?
Yes, my lord.
Yes,
my Lord.
Yes, we were about to start when we had a power outage. I apologize for that. We are starting now. I don't know if the registrar has connected from Lagos. If not, I can use the one here to continue the proceedings. Registrar.
Yes, my lord, I'm here.
It appears he's not. Registrar.
I'm here, my lord.
So we are starting now.
Okay, my lord. In the National Industrial Court of
Yes.
Nigeria, in the Judicial Division, holding at Lagos before His Lordship, Honorable Justice Mustafa, today, Friday, 2021. Suit number NICN/LA/234/2016 between Mr. Gabriel Adilan versus Technocrime Security Limited. Parties absent, my lord.
Yes.
May it please this honorable court. Olufisola Bada. Olufisola Bada. Olufisola Bada.
Yes.
And my obu appearance is for the defendant in this case.
Okay. Yes.
My lord, it seems there is no legal representation for the
Any appearance for the claimant?
Very well. Very well, my lord.
Registrar. Registrar.
Yes, my lord. Yes, my lord.
Was the claimant served? The counsel to the claimant, was he served? Registrar.
Yes, my lord, I'm answering you, sir. They are aware of today's sitting.
Okay. Yes.
My lord, the business of the day is the adoption of the final written addresses.
Yes.
My lord, we have filed our own final written address since 24th of January 2020. And we have duly served same on the claimant. But my lord, ever since we have served them, we have not gotten
Hold
any
on,
response.
I am recording, counsel. Speak loudly, please.
All right,
I am
very well, my
recording.
lord. Very well, my lord.
Yes.
My lord, we haven't gotten any response from the
Rules.
claimant. We haven't been served their own final written address,
Yes.
and we actually don't know whether it was also filed in the court with to the court rather.
Nothing was filed for the claimant in terms of final address.
As the court places, my lord.
Yes.
My lord, in the circumstance, we will urge this court to foreclose the right of the claimant to file their final written address. Despite the fact that there was a lockdown for the COVID, that's enough time for
That
them
is
to have
okay.
done the.
The claimant's right to file his final written address is hereby foreclosed. Dependents can proceed and adopt.
As the court places, we are grateful, my lord. My lord, we have a motion before this honorable court, and subject to the convenience of this court, we would like to move our motion.
You may proceed. Motion for
Is a motion for extension of time.
counsel.
My lord,
You said the claimant did not file.
very well, my
Okay,
lord.
you are the for the defendant, and you are supposed to file first. And
Very well,
it
my lord.
appeared you filed out of time. Okay.
Yes, very well, my lord.
Yes.
My lord, our application is dated
Was it served on the claimant?
My lord, sorry, sir.
Was it served on the claimant?
Very well, my lord. Very well, my lord.
So before you applied for the foreclosure, you should have moved this application. After the application is granted, then you can adopt and add your court to foreclose the claimant and adjourn for judgment. I think this is supposed to be the procedure.
As the court places, my lord.
I think this is supposed to be the procedure. You should move your application to file out of time, for leave to file out of time. After the leave is granted, you proceed and adopt. Then you can move the court to foreclose the claimant. Even though the claimant has right, the time within which the claimant to adopt its final address will begin to run now. In the circumstance, anyway, let me grant this. We can later correct the edition.
As the court places, my lord.
Yes. You shouldn't have moved the court to foreclose the claimant. If I knew you have filed out of time, I wouldn't even have foreclosed the claimant.
As the court places, my lord.
My son knows. I was
very
expecting
sorry
them.
for this one.
Silence. You may move in town.
My lord, we hereby move in terms of our application, and we urge this court to grant same.
Right. Take it to other matter. Come.
Dependents, can we have silence, please? The dependent's application to regularize his final written address, which was filed out of time, is hereby granted as free.
As the court pleases.
Given that the time, that is the 21 days within which the claimants may file his written address, begins to run now, the earlier order made for closing the claimant from filing the final written address is hereby set aside.
As the court
In the
pleases.
circumstance, the dependent cannot proceed to adopt until the time within which the claimant may file its written address as expected. This being the case, this case is hereby adjourned to December 10th, 2021 for adoption of final written addresses.
As the court pleases.
The hearing notice shall be issued and served on the claimant with proof in the case file.
As the court pleases. We are very sorry, my lord, and we are very grateful as well.
You should have told me earlier than now. I wouldn't have even entertained an application to foreclose the claimant. The rule is from the date the case is adjourned for adoption, the dependent is expected to file first within 21 days. Claimant also has 21 days from the date the claimant the dependent file and served on him to also respond. If there is a reply, I think it 7 days or 14, I cannot remember. In this case,
my lord,
the dependent is out of time. So the time will not begin to run until the dependent files and regularizes the process. Then the time will begin to run from that, the moment of regularization.
My lord, our application is before the Honorable Court for extension of time, my lord.
Was it taken? It wasn't taken. Huh? Until it is moved. Having not been moved, the fact that it was actually filed does not mean that it will begin to run from the date of filing until you moved it. It has not been taken till now.
All right, my lord.
Thank you.
As the court pleases.
Next.
Suit number NICN/LA/467/2017 between Mr. David Pricer Nai and Square Nigeria PLC. Parties are absent, sir.
Presentation of counsel.
The court, Kanyip, Father Hero. I most
Father
humbly
Hero,
announce
I
my
cannot see
appearance
you,
for
Father
the.
Hero. Where are you?
Yes, madam. I'm here, sir.
I cannot see
I'm
you.
here,
Can
sir.
you wave your hand? I cannot see you.
I'm here, sir.
Where are you?
I'm here, sir. I can see my Lord clearly, sir.
Where are you?
I'm here, sir.
I'm not seeing you.
I'm here. I
Can
can
you
see
wave
my
your
Lord
hand?
clearly.
Wave.
Mr. Father, I will wave your hand so that my Lord can see you.
I'm waving, sir.
Okay.
Yes, sir.
Yes.
Yes, I announce my appearance for the claimants, my Lord.
Okay. Any legal representation for the defendant? Registrar, for the defendant served.
Defendant counsel is online.
Okay.
Let me reach him so that he can unmute himself.
Nuruddin Balogun. Can you unmute yourself? I can see you waving your hand. Unmute. Mr. Balogun. You muted yourself.
Oh, my Lord, I'm so sorry.
Now we can hear you.
Yeah,
Now we can hear you.
I'm so sorry. You provide respect, sir. N.O. Balogun for the defendant.
N.O. Mr. Balogun.
Yes, my Lord. Yes, ma'am.
Yes.
Yes, sir.
Yes.
Yes, sir, my Lord. We have a routine application to regularize our written address, my Lord.
Are you for the defendant or for the claimant? What are you?
I'm for the claimant, my Lord.
Okay.
I'm for the claimant.
Okay. Mr. Balogun.
Yes, my Lord.
Are you
My Lord, we are not objecting to the application.
Okay. Mr. Padayo, you moved in terms of the
Pascal, please. In the absence of any objection from the counsel to the defendant, I ever move in terms of the application, and I urge my lords to grant him.
application dated and by when? Mr. Padayo.
Yes, the application is dated 3rd of December, my lord, 2020.
Filed when?
It was filed on the 4th of December, 2020.
Ordered as prayed.
As a couple,
I'm most grateful, man.
Yes, Mr. Balogun.
Yes, my Lord, our final address is filed 5th March 2019. Dated the same day, my Lord.
Yes.
And my Lord, in reply to my letter colleague's final address, we also filed a reply on the 14th January 2021.
Yes.
Lord, we humbly adopt these two addresses, our arguments in the matter, and urge the Honorable Court to dismiss the claimant's claim in its entirety. We are most grateful, sir.
Yes, Mr. Padayiro.
Yes, my lord. The claimant's final written address is dated 3rd December 2020. It was filed on the 4th of December 2020, my lord. We wish to adopt same as our written argument in this case, and we urge your lordship to grant all the relief sought on the statement of facts dated 25th September 2017. And we also urge your lordship to enter judgment in favor of the claimant. We are most grateful, my lord.
I've seen the other. No, I've seen the opposite lawyer now. Yeah.
Okay. This case is hereby adjourned for judgment on a date to be communicated to the parties through their respective counsel.
As a court proceeds. My lord, we are most grateful.
You're welcome, Mr. Balogo.
We are most grateful, my lord.
Thank you, Mr. Kendi.
Have a wonderful Christmas.
Thank you. I wish you happy Xmas in advance.
Thank you, my lord.
And you too, my lord.
Even though we'll meet before then.
But unfortunately, I will be leaving for the
We'll
US.
meet for the judgment. For the judgment.
Oh. My lord.
Yes.
Thank you, sir.
Next.
Suit number NICN/LA/244/2017 between Mrs. Adiola Oluyemisi Eze versus 1 Buttercup School Limited and 2 Lagos State Commissioner of Police. Parties are absent, sir.
Presentation of counsel. Representation of counsel. Representation of counsel. Registrar.
Yes, my lord.
Were the parties served?
Yes, my lord.
Yeah, because my case not being called. Huh? Because my case not being called. I've not touched anything. So what do I do? Come now.
Can we have silence, please? The registrar has said that both parties were served with a hearing notice of today's sitting, but neither the parties nor their counsel are in this court. In the circumstance, I will invoke the provisions of Order 45, Rule 7 of the National Industrial Code Civil Procedure Rules 2017 to deem the written addresses as adopted. The case is accordingly hereby adjourned for judgment on a date to be communicated to the parties. Next.
Suit number NICN/LA/491/2017 between Mr. Friday Hackman and Data Services Nigeria Limited and two others.
Parties, are the parties present?
Parties are absent, sir.
Presentation of counsel. Mr. Nzeta, unmute your audio. Unmute your audio, please. Yes, Mr. Nzeta. We cannot hear you. Unmute yourself. Yes?
Yes, yes, my Lord. I've done that, my Lord. Can my Lord hear me now?
Hear you now.
May it please
Yes.
this honorable court, I.R. Nzete for the claimant.
Pardon?
May it please your lordship, IR Nzete for the claimant.
Yes. Yes.
Due respect to this honorable court,
Yes.
UA Samson. UA Samson.
UA.
Samson.
Okay.
I'm appearing
Yes,
for
Mr.
all
Samson.
the defendants. All the defendants.
Okay. Yes, Mr. Samson.
Yes, my lord, the matter is slated for adoption of final written addresses of counsel and their parties.
Yes.
And their parties. My lord,
Yes.
the claimant's written address is dated the 4th of December 2020.
Did you file out of time?
Very well, my lord. I filed out of time.
Okay.
And I filed a motion to regularize the final written address, my lord.
Okay.
My lord, the motion is dated the.
Hold on.
Please.
Mr. Samson.
Yes, my lord.
Are you opposing the application?
My lord, we are not opposing. We shall not be asking for costs.
Can you? Yes, Mr. Nzete, move in terms.
My lord, I'm very grateful to my learned friend, Mr. Samson, for not opposing, and I'm not asking for costs as well. My lord, my application dated the. My lord, I move in terms of my application dated the 3rd of February 2020, and I urge your lordship to grant the relief sought. I'm most grateful, my lord.
Yeah. Dated what date?
My lord, the application is dated the 3rd of February 2020.
And filed when?
My lord, it was filed on the same date, my lord, on the same 3rd of February 2020, my lord.
Yes.
Well, I move in terms and urge your lordship to grant the relief sought.
Yes. Yes, Mr. Samson, okay. The application is granted as prayed.
As the court pleases. I'm most grateful, sir.
Mr. Samson.
Yes, my lord, with due respect to this honorable court, we filed a written address dated 17th of December 2019. Dated the 17th of December 2019.
And filed when?
And filed on the same 17th day, same date, my lord. 17th of December 2019.
Okay.
My lord, since my and before the courts.
Yes.
As the court pleases.
Yes.
My lord, since the claimant counsel have now regularized their position.
Yes.
For filing out of time.
Yes.
My lord, we intend to take 14 days to make a reply on point of law.
Okay.
Process filed by the claimants.
Okay. But Mr. I'm adjourning the matter to give you the opportunity to file the reply. But in order to save time, Mr. Sampson, you should have filed so that when the claimant regularizes their final written address, which they filed out of time, you can easily adopt and we will make progress.
Yes, my lord, I sincerely apologize for that. And
You
maybe
all know apology.
lastly,
You all
yes,
know
yes,
apology. I'm
yes.
just giving a hint so that it would have saved time.
Yes, my lord, let me explain this. The claimant counsel, even up to this morning, was of the view that he is entitled to file a reply, not us.
No.
Even up to this morning.
No.
That was the position I found myself.
That is not the
I said,
position.
okay, that the court will hear the position and streamline it. We are grateful to the court.
You're welcome. Mr. Ndete?
Lord, the claimant's financial address is dated.
No, you
the
are
3rd
not
of December.
Mr. Ndete, Mr. Sampson said
I
he
can hear my lord.
wants to utilize his 14 days to file reply. I just want to hear your response.
My lord, in the previous proceedings, the previous cases that were called before my lord, yes, I heard my learned friends mentioning a right of reply, but my lord, the order 45 of the rules of this honorable court is very clear. Reply of points of law, yes, my lord, and I like to refer my lord to order 40, my lord, order 45, rule. Order 45, my lord. Rule 9. I'm sorry, my lord. I want to bring it out. Order 45, rule 9. My lord, the defendants can only file reply on points of law with the discretion of my honorable court if my honorable court allowed them to file such process. Because my lord, this is the realized court. They can only file reply on points of law.
Which rule are you reading from? Which rule are you reading
I'm reading
from?
with the name of honorable court, let me read order 49 rule
Order?
Order 45, my lord, order 45.
Yes. Go ahead.
I think it's order 45, rule 13.
Rule?
I'm sorry, I didn't flag it. I want to read it. Yes, my lord. Order 45, rule 13, my lord, of the rules of the honorable court. Where the defendant fails or refuses to have a period of time to file his or her written address within the time limit ordered by the court, and the claimant has filed his or her final written address, the claimant may move the court for parties to address the court on points of law, my lord. My lord, I'm relying on the last limb of the provision. I'm relying on the last limb of the provision.
Yes.
Yes, my lord, the defendants filed their final written address in this case, and they filed within time, and we have a solid of court to extend time. My lord, they are not entitled to a right of reply on points of law unless my lord grants them leave so to do, because the National Industrial Court is realized.
Who told you? Counsel, who told you?
My lord, that is my understanding of the law, my lord. With due respect, sir.
Let me read order 45, rule 13 for your hearing.
Very well, my lord.
Where the defendants fails or refuses to ask for extension of time to file his or her final written address within the time limit ordered by the court. This is only applicable.
I said I'm relying on the last limb of the section.
And the claimant has filed his or her final written address, and the claimant may move the court for parties to address it on points of law. This is only applicable where the defendant fails to file and the claimant has actually filed.
As the court pleases.
and does not pin into the current circumstance. It
I
doesn't.
God please. But,
Yes.
but my Lord, I also
By
want to.
the rules, Mr. Nzeta, by the rules, when the trial is concluded, the case will be adjourned for adoption of final written addresses. The party that ended, that is the defendant, is expected to file first within 21 days from the conclusion of the trial. Then the other party also has 21 days within which to file. Then if there is a reply, if need be for a reply, then the defendant has 14 days to file a reply on point of law. And this is what Mr. Sampson is utilizing.
As God pleases.
Yes. So
I get it so explicit from my Lord. But my Lord, I also want to point it out to the Honorable Court that I was not formally served with the defendant's final written address. It was when I went to court to conduct search, I got to find out that they are filed. They didn't serve me. I wasn't served. When I filed my written address,
but you were served.
You know, I wasn't served formally. I wasn't for. I discovered it.
But it was actually reached you. It has actually reached you. It was served. You were served, even if not formally. Who served it on you in the court? Mr. Ndeta.
I can hear my Lord.
You were actually served. Whether you are served formally or not, the most important thing is for you to get the copy of the written address so that you will be able to make reply. Yes. So I will record that you are conceding. In the circumstance, this case is hereby adjourned to 16th of November 2021 for adoption of final written address.
God please. Sorry, my Lord. The case adjourned to the 15th of November.
Yeah. 16th.
Okay, 16th of November.
Yes.
As God pleases.
Yes.
I'm most grateful, sir.
1-6. You are grateful to the Honorable Court.
The defendant shall file the reply before the adjourned date.
As God pleases, we are most grateful to the Honorable Court.
Next.
Suit number NICN/LA/584/2017 between Joseph Luke Oluwadamilare and Chevron Nigeria Limited and one other. Parties are absent, sir.
Presentation of counsel.
With profound respect to this honorable court, sir. Babs
Yes.
Anima Shang. My lord, appearing with me, Babs Anima Shang, sir.
Where are you? Okay.
My lord, Babs Anima Shang. Appearing with Mrs. Rashida Akinrinde.
Rashidat
Akinrinde, my lord, sir.
Okay. Yes.
My lord, we are holding the brief of Mr. Olukayode Olatunji for the claimant, sir. For the claimant, sir.
Yes.
Thank you, sir. Yes.
Finish my
With the great respect to this honorable court, Ladipo Shweton appears for the defense, my lord. With the great respect, my lord, Shweton.
Yes.
My lord, the matter is for the adoption of written addresses.
Yes. Yes.
My lord, in this particular, yes, my lord, in this particular case, by the order of the court, there was no trial. The addresses were supposed to be based on the documents filed before the court.
What did you say, counsel?
My lord, in this particular case,
yes,
the claimant was in the US when the pandemic struck, and as such, he was not able to come to Nigeria. Counsel for the claimant then applied to court that we dispense with the hearing itself and argue the case on the records before the court. Because of that circumstance, my lord, the claimant was required to file his own written address first. Because my lord,
counsel, this did not capture what truly happened.
I'm sorry, my lord.
The claimant could not attend trial.
That's correct, my lord.
And parties decided to explore the trial or record procedure. And with the consent of learned counsel for both parties, this case granted the application. And we accordingly adjourned the case for adoption of written addresses. You are saying it as if it is the court that directed the parties to go.
I'm sorry, my lord. I'm sorry, my lord. It was upon application of counsel and by agreement of
with your consent. Yes.
As the court pleases.
Yes.
My point being, my lord, that it was the claimant that was required to file his written address first and not the defendant. That was the reason why I went into such a long story.
Okay. So are you ready now?
Yes, my lord.
My lord, we are ready, sir.
All right. Thank you.
Learned counsel to the claimant, will proceed, please. You may start.
My lord, the claimant's final written address is dated the 18th of October.
Okay. Anima Shaun.
Yes, but Anima Shaun, my lord.
The claimant's
final written address, sir.
Written address
is dated.
Yes. It's dated.
The 19th day of October 2020, my lord.
Yes.
My lord, we seek to adopt same as our argument in this case.
When did you file?
My lord, it was filed the same 19th of October, sir.
Dated and filed.
19th day of October 2020.
Yes.
My lord, we seek to adopt it as our legal argument in this case. And we urge this honorable court to find in favor of the claimant, sir. By way of adumberation, my lord.
Yes.
My lord, we raised 5 issues in our final written address.
Yes.
My lord, we have argued on all the 5 issues.
Yes.
And my lord, I would like to draw the attention of this honorable court to our issue 1 particularly, sir, and especially, and as well as issue 2, my lord, and which is to the fact that all the averments that we have stated in our claim were not controverted, which in itself is a form of admission. My lord, we have argued as to the effect of the lack of controversy, as to the failure of the defendants to controvert our averments. My lord, the defendants also tried to, especially the first defendant, they tried to lay ambush by saying that there was no claimant, there was no relationship of employment between the two parties. My Lord, we have also debunked all this. And my Lord, we urge this honorable court to find for the claimant.
It's okay.
As from the facts of the case, as well as the documentary evidence before the court.
It's okay.
As the court pleases.
Thank you. Mr. Soetan.
Yes, my Lord. The defendant has filed a written address, my Lord, that was filed on 18th of November, 2020, my Lord. It was filed on the 18th day of November, my Lord, 2020. My Lord, we will seek to adopt this written address as our argument in support of the case of the defendant, my Lord. My Lord, there's just one there's a small error of the address, my Lord. Page 15, paragraph 4.453.
Yes, Mr. Sweater. Can you hear me?
Yes, my Lord. The actual fact is that the claimant resigned. Yes, my Lord, I can hear, my Lord. I can hear, my Lord.
Yes.
I was drawing my Lord's attention to page 15 of our brief, our address, my Lord, paragraph 4.453.
Yes.
And I said, my Lord, the actual fact is that the claimant resigned his appointment and he was not terminated. So the fact I mentioned there is actually incorrect.
Yes.
Yes, apart from that small error, my Lord, we wish to adopt this written address as our arguments in support of the defendant's case. I think it adequately addresses the points that my learned friend had raised. We said that they have to put the witness into evidence, and they cannot rely on their documents they tendered as evidence. They were the one who applied for a trial by record. So we are not accepting the veracity of any of the documents they provided. That is all, my Lord.
Okay.
My Lord, we have a reply on points of law, sir. My Lord?
Okay.
Yeah, our reply was filed on the 16th day of December 2020 and is equally dated 16th day of December 2020, sir.
Yes.
My Lord, we have addressed the issues that their defense thrown up in our reply, sir. My Lord, particularly the fact that a party cannot be allowed is dated 16th day of December 2020, sir. 16/12/2020.
Yes.
My Lord, it is tried that a party cannot be allowed to approbate and reprobate. Having consented to the hearing of this matter, the way it has been heard, my Lord, I think it will be too late. My Lord, I adopt it as our argument in this case, as our response to their defense, to the defendant's reply, to the defendant's written address.
Yes.
My Lord, we have adequately responded to everything they have stated in their reply, in their final written address. My Lord, a party cannot be allowed to approbate and reprobate, having consented to the hearing of this matter, the way it has been heard. My Lord, I think it will be too late for them, and it will also be wrong for them to now take a U-turn and start attacking the mode of hearing of this matter. My Lord, the claimant is still suffering. He has not recovered from the injuries he suffered. My Lord, the court of law is a court of justice. The manner of hearing of this case and the entire proceedings should not be a thing about it. It should not be used as a game of hide and seek.
Well, we'll address that issue in the judgment.
As the court pleases. My lord, I adopt it.
Leave no stone unturned. We'll address all the
as
issues.
The court pleases. As the court
raised
pleases,
by
my
the
lord.
parties.
I'm most grateful, my lord.
So, okay.
Yes, I'm very grateful, sir.
This
We are
case
here
is
for
hereby
justice.
adjourned.
My lord,
Judgment.
my lord.
Yes.
Sorry, my lord. Rashida Akinride, my lord.
Yes.
Sorry, if not because we are on Zoom, I will have said it to my learned colleagues there that we just want to make this correction, that the claimant's final written address is actually dated 10/10/2020, but filed on the 19/10/2020, my lord.
Okay.
Yes, my lord. Thank you, my lord.
Thank you for the observation.
Much, my lord. Thank you.
This case is hereby
I'm sorry for
adjourned
the error, sir.
on a date to be communicated to the parties.
As the court pleases.
We are most grateful, sir.
Very
Thank you
much
very much.
obliged.
The date for judgment will be made known to the parties. Due course.
As the court pleases. We are grateful.
As the court
pleases.
We are most
This trial or record procedure is provided for in the rules of this court. Order, I think it is 38, order 38, order 33, I think so.
Order 38 rule 33, my lord.
Order 38 rule 33. The provisions are very clear. It is amenable to certain kind of cases. It obviates the need for putting witness in the witness box, so long as documents
as
arguments of parties can help the matter. And we are going to address this issue in the judgments.
As the court pleases, sir. We are most grateful, my lord.
Next.
Suit number NICN/LA/45/2018 between Mr. Olatunji Sunday and First Nation Airways Limited. Parties are absent, sir.
Okay. Representation of counsel. Representation of counsel. Bishop.
Yes, my lord.
The parties served with the hearing notice of today's sitting.
Both parties were informed of today's sittings, my lord.
There is no appearance for either side, nor are the parties in court. The registrar told me that the parties are aware of today's sitting. In the circumstance, I have no option but to invoke the provisions of the 45-7 the National Industrial Code Procedure Rules 2017 to deem the final written addresses as adopted.
As court, please.
Deemed. This case is accordingly hereby adjourned to for judgment on a day to be communicated to the parties.
As the court pleases. That will be all for today, my lord.
Thank you.
Yes, my lord.
Court shall rise.
Court.